Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Adam Jarvis, an Alabama construction lien law expert. Today's webinar topic is Don't Sign a Release Unless It Says This One Thing. So without further ado, I'd like to introduce the fabulous Adam Jarvis.
Thank you. I'm Adam Jarvis. I practice law for myself, Jarvis Law Firm in Mobile, Alabama. And a lot of my practice is dedicated to construction law and mostly construction collections, a little bit of construction defect, but the collection side and the defect kind of go together. If you have any questions, there's a chat box on your right, and hopefully we'll have some time to answer them at the end. Go ahead and use that if something comes up you'd like to talk about. Some of the things that we're going to talk about today, we're going to talk about briefly some things to look out for in your contract that can affect your ability to collect on work that you've completed after the fact. We'll talk briefly about partial and final releases, and then the bulk of our presentation today will be about general releases that arise once somebody's threatened litigation or litigation has actually been filed in order to resolve and settle that litigation. Within that, we'll talk about getting the parties right, talk about payments and timing, terms in the release that you want to look for, maybe some things to avoid, and then Jesse can talk a little bit about SunRay after that. First, we'll start with your contract, and some things that can often be in there that you overlook, you don't even go by, but if you notice can present a problem. I've increasingly been seeing some business owners, commercial business owners, putting lien releases in the construction contract itself, so that whether it be a general contractor or subs or sub-subs are by the terms of the agreement, waiving their lien rights before they've even started the project. Now, it's my opinion that in Alabama, you can't do that. You can't waive your lien rights before you've done the work. The problem with that is that in order to get a judge to say that those terms in the contract are enforceable, that they don't mean anything, you can spend a lot of money on lawyers. Both sides can spend a lot of money on lawyers. You have to get over the hurdle of declaring that lien waivers in the contract are unenforceable to then go and enforce your rights. And so, I've often advised my clients when they bring me, a contract to take a look at with a lien waiver in the contract, to either, omit that section from the contract or say, this is not a project that's worth dealing with if you've got other ways to make a living, if they won't budge on getting rid of that term. With respect to partial and final lien releases, you guys, this is what you do every day. And I don't see a lot of problems that arise with respect to, standard forms that you see every day for partial and final lien releases. One thing that's important to me is that we make sure that the amount of money being released matches the amount of money that's being paid. And, on your payment applications, of course, it breaks out, what you've earned and what percent, or what's been completed, and then what part of that may be retainage. And I'd like for, on the release, that amount of money should really match what is being paid, not the total amount earned, so that you're not waiving your lien rights on retainage that you haven't received in payment yet. But that's one issue that's come up. But typically, my commercial contractors, we're often using AIA forms, American Institute of Architects, and those are great because everybody's familiar with them. If you wind up, on a project where you've got, especially if you're a subcontractor and you've got a general contractor giving you lien releases that look more complicated, that might be something that's worth, just taking 10 or 15 minutes to run by your local attorney, somebody like me, to just give it a read and make sure there's not something unusual in there Again, trying to make sure that we don't release our rights for things that we haven't been paid for along the way. Now, here we get to, the more complicated types of releases and where there can be more problems. General releases are usually the type of releases that are created when there's been a threat of litigation or litigation has already started. And, some of the issues that I see with that, typically they may arise because of failure to pay, and they may equally arise because there's been an allegation of a construction defect. I guess in practice, it's often that, somebody files a lien because they haven't been paid, and almost as a defense, the owner, starts alleging construction defects that they weren't complaining about prior to that time. The two kind of go hand in hand. But one of the things to think about is who is releasing whom. And I really don't like one-sided general releases. If there's litigation that's been threatened or has been filed, the releases should really be mutual, that everybody is agreeing not to sue everybody else. You wouldn't want to give up your right to sue and then the other party a week later turn around and sues you. And so releases should be mutual, and we really need to be careful to make sure that the right parties are involved. Often I see that you've got a construction contract that is from a developer, but they've got a related entity that owns the piece of real estate. And to make sure that we've got all of the parties that are involved that need to be in the release, and not leaving somebody out that's important to making sure that any litigation that's going to come out of this project is finally put to bed. All parties should have to sign, and we need to make sure that the person who's signing for each legal entity, whether it be a corporation or an LLC or a partnership, has the authority to sign the document. So often I see agreements that just have a signature line, but we don't really know who the person was that signed it, or especially if you were showing it to a judge who doesn't know anything about the parties. And then I really like to get signatures notarized, just to put to bed that those were the actual person who did sign the releases. And with respect to payments and timing, we want to be as specific as possible about the amount of payments that are going to be made and how that payment's going to be made, whether it be wire transfer or bank or other certified funds, whether cash is fine, or whether, in some cases you may be accepting a promissory note. And when will that payment be made? And one thing to think about, when you have a meeting, often wire transfers close from a bank kind of early before the bank itself closes. And so, I try to structure meetings if we're going to all get together in my conference room or another lawyer's office and execute releases and make payments at the same time early enough that those wire transfers can be made on the same day and completed as we sign documents. But the more specific you can be about how and when payment is going to be made is really to your benefit. That's not the right place to make assumptions. In terms of release terms, what to look for, what to look out for. We want to make sure that a general release, the type of release that is to resolve threatened or filed litigation, includes everything. And so, the lawyer words that we'd use, we'd say that claims that arise out of contract or in tort or in equity. And when we talk about equity, the legal claims, we call them quantum meruit or unjust enrichment. And when I file a construction complaint, typically you'll include all of them on the complaint. Breach of contract, negligence, wantonness, maybe warranty claims, and then quantum meruit, which is the same, it's a Latin phrase, basically the same as work and labor done, a reasonable payment for the amount of work that was done and authorized by the owner. and then unjust enrichment, somebody got a benefit they didn't pay for. All of those should be included in the release. It should also include all claims that are known and unknown. When you sign a release and you make a payment, we want to put to bed everything. And so it shouldn't be a defense to the release that the claims were unknown. They should include unknown claims. And it should be arising at any time prior and up until the time of signing. You're typically not legally allowed to waive claims that would arise in the future. That's a matter of public policy, which makes sense because it's hard to waive rights when you don't know what they're going to be or what the issues are going to be. But it should be for any time up until the time of signing. What's being released? Sometimes there are things that will survive a release. And so if there are remaining items that are still, obligations of the parties, obligations of you or another contractor, we want to be as specific as we can, whether that be punch list items or warranty work. And so to know exactly when that work has been completed or hasn't been completed, but with not a gray area or any guessing, we want to make it as objective as possible. We want to identify who is going to perform that work. And certainly if the answer is not you, you'd want that spelled out so that somebody doesn't later claim that you've got to, have additional expenses on a project that you think that you're really done with. And then when will that punch list item be finished, or when will that warranty work be completed? Again, being as specific as possible so that everybody knows their rights, what they're agreeing to, and what they're waiving. If there has been litigation filed, the release will definitely want to include or certainly the conversations around the release, if not in the release itself, that it'll include the dismissal of all litigation, and you probably want to reach some agreement on who's going to prepare that, who's going to file that, so for sure, are you paying your lawyer to do it, or can you there's a party being paid by an insurance company, can you make that party covered if some other people would have to do it out of pocket. Typically, I like confidentiality and non-disparagement clauses in releases. One thing about the confidentiality, and I may not have put that on this list, but it should go in this list, is no admission of wrongdoing. All of the parties should say that we're agreeing to this release, this settlement of the issues, because of the time and expense that would be required to fight it, but not because we admit that we've done anything wrong. And then along with that, we want to keep the agreement confidential, so that the parties promise not to share it with anyone other than typically legal counsel or as required by law. And non-disparagement goes along with that. Like the parties not to talk badly and ruin the other party's reputations after the agreement's signed. You'd hate to settle with a party and think that you put the issues in a construction project to bed, and then the next day they're on Facebook talking about how much they can't stand your company and think other people shouldn't hire you. So a non-disparagement clause is I think important, because you may not have entered into the release if you'd known that there was a risk that somebody else was going to say negative things about you after the release was executed and payment was made. It should include release of all claims, including attorney's fees, but except as to enforcement, and that's where that's related to the confidentiality and the non-disparagement. If another party to the agreement breaches the agreement to keep the terms of the agreement confidential or disparages your company, you should be able to recover your attorney's fees that had to be expended in order to enforce that agreement. That is everything that I've included in my part of the presentation. Jesse, I'll kind of turn it over to you if there are any questions.
Well, first of all, Yeah, first of all, that was amazing. Thanks so much, Adam, for that, for your time and putting this together for us. We appreciate it. There was some really great information here. There is a question that has come through, and it says, is there a standard release form that must be used in Alabama?
No, no, especially for construction work. The release should be tailored by the parties and their attorneys to match what needs to be released. There are some standard release forms out there, and typically, one law firm often uses the same form over and over and over because it's so broad and so general. And but there is no standard document that has to be used.
Okay.
That's something that is typically drafted for the situation by the parties and the lawyers.
Perfect. Thank you. Another question that came through is, what if I accidentally sign an unconditional release, but then don't receive payment? What can I do? Do I have any lien rights still?
You probably do, and that is an issue. I mean, I really try to, when it's possible, not share the final signed version of the release until we're getting payment at the exact same time. I suspect that there are rights that are available, but you'd want to look at the terms of what the release says itself, and you probably want to meet with a local lawyer and talk about the specific facts of the situation in order to get a real firm answer on your particular situation.
All right, perfect. Yeah, it's really important to make sure you're reading what you guys are signing ahead of time so you don't have those whoopsie moments. All right, so I think that is all the questions that have come through so far. If anyone does think of another question that hasn't been addressed, please feel free to reach out to me. I'll be sure to answer any questions as soon as possible. Can you go to the next slide for us, please, Adam?
Sure.
All right, so here are some of SunRay's resources to help you guys stay organized, know your deadlines, secure your rights. So go ahead and scan that QR code to access these incredible resources. There's deadline calculators, a project information sheet that is really, really helpful when you're first starting these contracts and work. You'll be able to get some of the information, find out who's up the chain from you, so you know who to be sending some of these notices to. And there's also state lien law rules by each state. Remember, each state has their own set of lien laws, deadlines, and documents that are required. So if you go to our website, you can check it out if you're working in a nearby state and you need to find out, okay, I'm working on a commercial job and I'm the subcontractor. What do I have to do? It will break it down for you. So check it out, see how we can help you. All right, go to the next slide for me, please.
All right.
All right, if you don't mind, take a moment to give us a review on Google. It takes about a minute of your time, but it helps us get other information and out to other contractors like yourselves. You can give us that feedback as to what other types of content you'd like to hear about and see how we can help you. All right, and then the last slide, if you don't mind, please. And with that, that is all we have for you guys today. Thank you so much to everybody who did attend. We hope to see you guys at our next webinar. Adam, again, thank you so much. You were really incredible. I hope you all have a wonderful and sunny day. Thanks, everyone.